Hello everyone, I'm Brad Hutchins and this is Allie Jett. We're with the law firm of Weissman, Nowak, Curry & Wilco in Atlanta. And we're here to follow up on our video we did back in November where we discussed the M7 case dealing with excess proceeds coming out of tax sales. We want to follow up on that case, bring your attention to another case that's out there, and bring up a couple of bills that just came out of the legislature. First, the M7. Remember, it was the case that dealt with who gets proceeds, the excess proceeds after a tax sale. Since our last video, that case went up to the Georgia Supreme Court. Cert was applied. No word from the Supreme Court yet as to whether they're going to take the case, so we still don't know the ultimate resolution of the case. We'll update you when we know more.
Another case that you should all know about is the February 24th decision of Raw Properties versus Lawson. And that case addressed the issue of whether or not a tax commissioner could be held liable for failure to send out pre-sale notices or just improperly sending out those notices. There was a case in the late 90s addressing the issue of whether or not improper noticing, pre-sale noticing, invalidated a tax sale. There the court determined that it did not, but said nonetheless the property owner may have a claim against the tax commissioner for damages for improper noticing. So finally we have a case that has come out that has given us the answer to that question. Here the court determined that in fact the DeKalb County Tax Commissioner had no liability for failing to send out notices to a new address for the taxpayer with the tax sales. So, but like with the M7 case that Brad just talked about, this case has also been appealed to the Georgia Supreme Court. So that just happened last month. The court has not determined whether or not it's going to hear that appeal. So for the time being, the Court of Appeals decision has stood, but that could change if the Supreme Court decides to take it up and come up with a different decision. One thing we do want you to note about this case, it could be specific as to the way DeKalb County runs things insofar as they do all of their pre-sale noticing internally. This does not address the issue of whether or not there could be liability if a tax commissioner uses third-party vendors. So we just wanted to let you know that's an open question that could be addressed in a subsequent case.
The first of the two bills we want to highlight here today is HB 991. It was sent to the governor on March 28th. It has not yet been signed. Of course, it passed both the House and the Senate and the legislature. It's called the Returning Heroes Act. Now, what this act says is that if someone is in the military serving in an area that has been designated by the President of the United States as a hostile war zone, then when that person returns from active duty service, they can notify the tax commissioner that they were overseas. And if they didn't pay any property taxes while they were serving in the hostile area, they get 60 days to pay the full principal amount of the tax due and owing. And if they do that, the tax commissioner must or shall waive all interest and penalties that have accrued on those taxes while the person was in the armed services serving overseas. The question is, or a couple of thoughts are, one, how do you know if the person's serving overseas when the taxes go delinquent? I will tell you that in checking the federal government's website to determine if someone's on active duty, that site's been down for months. I don't know how you do it. The second is, what if the taxes do go delinquent? You levy, you issue a FIFA on the taxes. Can you levy on that FIFA while they're gone? What if you do levy and they come back and you find out then they were away in the armed forces? What happens? We don't know. These are thoughts to consider.
Another bill that has passed both houses and is sent to the governor is HB 960. That bill was sent to the governor on April 5th, also awaiting his signature. I would encourage everybody to read that bill in its entirety. There's a lot of information in it, and it seeks to change at least 4 code sections and to create a new one. I'm going to focus our information primarily on the 2 sections that deal with the change in interest rate and penalty for taxes going forward. On the interest standpoint, we are changing from a 12% per annum interest rate to bank prime loan rate as set by the Federal Reserve plus 3. Currently, that bank prime loan rate is 3.26. So the new annual tax rate would be 6.26, although that could certainly change from year to year, and you're supposed to adjust your interest rate in January of every year based on what that current prime loan rate is. As for changes to the penalty, I would say that's probably an even stranger or more significant change than even the interest rate. Here, instead of a one-time 10% after 90 days penalty, the legislature has set up incremental penalties. So every 120 days, a 5% penalty will happen. So you'll have a 5% at 120, 240, 360, and 480 days, assuming that the taxes remain unpaid for those full 480 days, so that it's not to exceed an aggregate of 20% total once all of the penalties have attached. This bill, like most bills, if assuming it is signed by the governor, will go into effect on July 1st, 2016. It purports to apply to all taxes that have been issued from July 1st, 1981 forward. So you will have a change mid-tax year to both your interest and your penalty accrual methods. So just something to be prepared for if that does in fact come down the pike.
Questions too, does this apply to prior years FIFAs that have been issued? I mean, for 2015 FIFAs, as of July 1st of this year, do they get to accrue the additional 10%, the 2 5s that will come due in that incremental time period after July 1st, so that that person or the county holding that FIFA collects a total of 20% penalty? What about the 2013, 2014s, the older FIFAs that are still out there? What penalty do you use? Do you get to add another 10% penalty on those on top of the 10 because this applies to all taxes that were issued after July 1st, 1981? I don't know. We don't know the answers. I suggest that tax commissioners and tax collectors may want to seek guidance from the Department of Revenue or the state AG's office, because you don't want to collect too much taxes, but you don't want to collect too little either.
Thank you so much for joining us today. We look forward to bringing these videos to you, and I'm sure we'll be in touch soon.